It is.
So
what
yeah.
It is.
Those are some of the little things people get to know that Charlie trouble day or trouble no day.
Trouble day. And I call you. You go and you know that there's fire on the mouth.
But this particular
What?
clarification or disclaimer. You can still be babed, and yes, what will hit you afterwards will shock you for the rest of your life.
Those ones are the slow poison.
You can be called babe.
The slow poison.
Like imagine that some extraneous variables have been discovered, right?
Yes.
Right. And then you have questions to answer.
The tone of the babe will determine whether you are in trouble or otherwise. So babe, like
for that one,
you're excited. Babe, it's sweet, but let's say
it's harmless.
Babe.
Hey, that one they've done it.
It's all about the tone.
I know, right?
Anyway, Muntala is here. The champion legal affairs.
Morning, Dedei.
How are you?
The man of our time.
How are you?
Yourself?
I'm well, thank you for asking.
Yeah, babe, you're looking so sweet this morning.
When we asked you simple question, you could not answer. And how come to babe me? Don't babe me and come and send the
simple question. Ask the question again.
I will ask you. When I was asking
you ask the question again. Now I'm ready to answer you. Not ask the question again.
Is that what?
Now I'm ready to answer you. So ask the question.
Let's move forward.
That day,
yesterday, court was trending because the report was that Salif Amwako and his wife and the other suspects had been discharged and then subsequently rearrested just at the entrance of the same court, right?
So that's always how it happened. So there were a lot of people who were alluding this very incident to the other cases that have been truncated by the Attorney General and all of that. But the scenarios are different, the circumstances are different. So Salif Amwako, Bishop Elisha Salif Amwako, the wife Moha Amwako, then Linda Bonso Prempe, they were in court in relation to that 14th October. In 12 October's incident, is it 12 or 14? I think it's about 14 or 12 of them. October, when the 16-year-old son of the bishop got involved in an accident in a manner that happened, led to the death of two 12-year-olds. And that matter, the young boy was charged, the parents were also charged. And so, two the separate cases, we know what has become of the young boy. The juvenile court has sentenced him after he admitted the offense. Initially, he denied the offense, then upon sober reflection, he admitted to the offense and has been sentenced to a 6-month sentence to the senior correctional center. But the parents have been in court. They have pleaded not guilty to one count, permitting unlicensed person to drive. And so that case has been before the court. And after they denied the offense, they've been granted bail 50,000 Ghana cedis each, 2 sureties without justification. The court asked that they keep their own passports, but they should notify the court whenever they want to travel and all of that. So prosecution was to file necessary processes, disclosures, and then witness statements. So disclosures had to do with any other document, any information that is relevant to the case, even those that the prosecution intend not to rely on, but it bothers about the matter. You have to make it available to the accused persons, to the court, so that the accused person, especially when they are mounting defense, will be properly placed to be able to defend themselves well. And so that was the process. That was the stage that the case had got into. But before yesterday, before the last adjourned date, before it was adjourned to today, prosecution led by Ebenezer Yao Akwa, a state attorney, notified the court that their intention is to withdraw the charge sheet that was filed at the court. They want to amend the charge sheet. So the expectation is that a new charge sheet was coming.
Okay.
And so at the last court sitting, that was when we have the new Attorney General in place. So the prayer to the court was to allow the new AG to look at the docket, to study the docket, and give his advice on that. So that has become very apparent. So it was adjourned to yesterday. And in court yesterday, the prosecutor or the state attorney indicated to the court that yes, about a study of the docket that we informed the court about, the new Attorney General has directed that further investigations be conducted into the matter. And that has been done. So for the meantime, what they intend to do is to withdraw the charge sheet as it is before the court for the accused persons to be discharged. And the court also granted opportunity to the defense lawyers for them to also offer, well, some situations, somebody will oppose to that and they'll give reasons why they oppose to that. And this time they are saying that initially they wanted a null prosecutor, but they said that, look, once the AG is saying that they withdraw the charges, we are in support of that. So the court presided over by His Honor Mr. Samuel Bright Aqua indicated that yes, if the prosecution that initiated the case is saying that no, we are coming for a withdrawal, and the defense lawyers are in support of that, what then would the court do? The court has no other option than to grant the request by the prosecution. And so the request was granted, and then the charge sheet as it is before the court was withdrawn or was struck out as withdrawn, and the accused person were dismissed. The judge said, I am done. So I am done. The accused person was still in the docket. And he said, my lord, because you said you are done, because you said they didn't hear they are discharged, so they are saying, I said, okay, you are discharged. So the court discharged them. And guess what? Immediately when they walked out of the courtroom, then they were invited to approach the police van because there's a rearrest. They have to go with the police because there is some latest information that has come in relation to the investigations that the police had, the prosecutor has indicated to the court. And my understanding from that situation was that they had two options in mind. One option is to come to court and every now and then indulge the court or ask the court to grant them an adjournment to go, come. But they felt that would amount to waste of time and resources at that particular point in time. The charge sheet before the court looks like it is very weak, and if they are to pursue with that one, it might not get them anywhere. So why don't we withdraw it? Upon further investigations, we'll continue with or file fresh charges as it is. So in the interim, we want to take this case off, let the accused persons go, but then let's rearrest them. Then possibly we'll grant that police inquiry bail. And on the police inquiry bail, when you're on a police inquiry bail, it means that investigations are underway at any given point in time when the police think that they are satisfied, they have enough information to file fresh charges against you. They invite you. And also when they invite you, you are informed that you have been arrested and you are being arraigned before court. So when you have police inquiry bail and you are going, if the police is done and they want to charge you for court, they will invite you. Once you come, then they arrest you officially and then arraign you in court. So that is what they anticipate, and that is the picture in relation to why this very late charge sheet before the court was withdrawn. So yesterday, yes, the charges were withdrawn. Yes, prosecution said that they are conducting further investigation. The court granted that. They charged the accused person, and then just when they opt out, or they were out of the court's room. You can't do rearrest in the courtroom. No. So once you come out, immediately you enter. In some situations, it results in fights because lawyers will advise their clients that the police are there, they want to rearrest you. Sometimes when they get a wind of it, the information margin, they want to rearrest you. So stay in the courtroom. But for how long can you stay? From the morning, the court closes at 4 p.m. So the highest or the number of you can spend time up to about 4 o'clock. Definitely you come out. And immediately you step out of the courtroom, you'll be arrested. And sometimes it becomes very messy and all of that. So in this situation, it wasn't. It was very friendly, very cordial. They were invited. Which car is that? So the conversation really was about whether they are using the police van or whether they should go in another car with the officers. They were not in a police uniform. They were plainclothes officers that, in fact, came for them and all of that. So that was what happened in court yesterday. Moment after they are discharged, they were rearrested. And currently, my understanding is that they are on police inquiry bail pending the outcome of the further investigation directed by the Attorney General.
And another case that has been on our table from time to time is the Gregory Afoko case. You recall that after the Attorney General made some remarks some time back, you said if you were in the position of Gregory Afoko's lawyers, you'd probably put in a fresh application for bail.
You recall that very well.
Yes. And interestingly, yesterday they put in a request for a bail after a very long time.
Yes. So
they put in that a number of times and it's been turned down.
Absolutely. So if you look at this very case as it is, May 20th, 2015. So May this year will be 10 years exactly when the incident happened. So we are in February, March, April, May. So a little over 2 months, then the case will be 10 years. And ever since, Afoko has been in lawful custody. In 2019, sometime in 2019, March, Justice George Dedei granted him bail after the very first trial was truncated. You note that in between 2016 and, beg your pardon, 2016 and 2019, the first trial took place, and it was only Afoko. Justice L.L. Mensah, the popular L.L. Mensah, when you go to Justice Lawrence Lazagla Mensah, I remember very well, who was the one handling the very first case. And just when he was about to sum up the trial for the jury to come out with their decision, the second accused was arrested. The AG entered nolle prosequi, so the first trial was truncated. Between 2019 and 2023, the second trial started. When the first trial was truncated, lawyers went to the High Court for bail. Justice George Dedei granted him bail, 500,000 Ghana cedis with 2 sureties. And it became an issue. Remember that at some point that the IGP and the CID boss were hauled before court for contempt because they felt that the man has satisfied all the bail conditions, but still they were keeping him in lawful custody. But that case didn't suffice. Then later on, when the fresh charge sheet was filed, State made an oral application for him to be remanded into prison's custody, which was granted by the presiding judge at the time, Justice Ifua Meliwood, a justice of the Court of Appeal at the time, who handled the matter. She is now on retirement. She rescinded that bail that was granted by Justice George Dedei because he felt that this is a fresh matter and it's a fresh case that had been filed. So the old one, bail condition will no longer hold. And then the matter went to full trial. Then sometime in April 27, 2023, specifically, prosecution ended their case. They called 16 witnesses, and the case was closed. Both parties, in fact, Afoko called only one witness, his brother Ishmael Afoko, to come and testify. Asapke Alande. In the second trial was Afoko and Asapke. The first trial was only Afoko, but the second one was after the Asapke was arrested. So the two of them stood trial for the second one. Then April 27, the jury returned that controversial verdict: 4-3 for Afoko on both counts, conspiracy and then murder. But they returned a unanimous verdict of guilt against the second accused person for conspiracy. But on the main charge, the substantive charge, which is murder, they returned 4-3 not guilty in his favor. So Asapke was convicted for conspiracy and sentenced to death. At the time, the death penalty was still in force. The laws have not been amended, but was supposed to be back in court with Afoko for the other leg that he was found not guilty. And that is where we are now. So ever since the retrial for the second one, he's made in October 2023, he made a bail application at the High Court. It didn't survive. He went to the High Court again, this time around the Human Rights Court, and sometime in October. It didn't work. It was dismissed. Then since then he has been coming to court, and the third retrial at this particular point in time, the fifth prosecution witness had testified and then has been discharged. In fact, prosecution indicated that they are still maintaining their 16 witnesses. So yesterday, we were expecting the sixth prosecution witness to come and testify. But unfortunately, when the matter was called, one of the jurors was absent, the foreman was absent. And once one person is absent, no show, nothing can be done. So yesterday, Justice Marie Louise Simon, who is the third judge handling the matter, has adjourned the case to March 5 for continuation. Then the news of the moment came that, oh, the lawyers have filed a fresh bail application, which will be considered on Friday. So the information is that Gregory Afoko has filed latest fresh bail application. This will be about the 5th bail application that he's filing, just so he could gain his temporary freedom as a case wore on. So on Friday, we'll be at the court. His lawyers, Stephen Suwachawe, who was holding brief for Safo Boabin, was there, and Rikujo Voltia, who was representing the second accused person, was also there. And of course, prosecution led by Marina Apia Opare was also there, and then the court was presided over by Justice Mary Louise Simo. So Friday we'll be in court to know more whether, and like you mentioned, this AG had made a point about Afoko, and I will not be surprised that the state will not oppose, and then Afoko, for the first time in nearly 10 years, will definitely or probably gain his temporal freedom until such time that the matter is disposed of.
A long way to freedom.
A long way. And yesterday, Oliver Barker was also in court for the treason felony.
Yeah.
And yesterday, unfortunately, the court presided over by Justice Mary Mamikwe Yenzo was expected to supervise the jury selection, but we didn't have enough potential jurors for the process or the paneling to happen. So the case has been adjourned to the 18th of March 2025, hoping that at that particular point in time we'll have enough. But in between that time, a lot could happen. In between that, it's one of the cases that could possibly be truncated along the line. Yeah.
Let's
so these
see.
are some of the things that we should. And
Let's
today
see.
there's not much happening, but of course days that you think that there's nothing happening,
That's
around
when
the court,
there's some
that is
action.
where you'll be surprised. So stay tuned. We'll have more for you.
All right. Thank you very much.
Yeah, thank you, babe.
Hey, Masa. What is the meaning of this?